After Advocate Andrea Johnson reported sick and her testimony at the Madlanga Commission was delayed, most of us, we thought that when she comes back, she's going to lay bare everything and literally address all the questions that we as the public have been asking ourselves. However, she came and said some things that kind of look like this.
I honestly cannot remember. I will exercise my right not to incriminate myself. It would be inappropriate for me in this affidavit to address the merits of the prosecution.
On the other hand, the trial of Vusumuzi Matlala is getting more interesting because the judge decided that he's going to put the advocate that is representing Vusumuzi Matlala in her place when she wanted to interject and comment on another legal representative's cross-examination. Imagine the audacity
of what happened.
This is case number, sorry Ms. van der Heever, this is a matter simply between counsel for accused number 2 and the state.
Lord, to the greatest of respect.
I'm not going to hear you. Thank you.
So your Lordship.
In this video, we'll talk about what has been going on at the Madlanga Commission, how insane that testimony went, especially when Justice Mbuyiseli Madlanga started teaching Advocate Andrea Johnson Introduction to Law 101. Insane and very interesting to watch. On the other hand, I also wanted us to touch base on some of the things that were discussed in the trial of Vusumuzi Matlala.
That's subjective. You cannot have it both ways. Law 101 says subjective, you look to the person's mind. Objective, you test that in accordance with how a reasonable person would view the situation. The two are totally different. You cannot want to compound them. You simply cannot. You cannot say it's subjective, but then also refer to a reasonable person test. You cannot.
So let us start with Andrea Johnson. So Andrea Johnson appeared at the Madlanga Commission, well-anticipated testimony on Tuesday, and she started her testimony, a lot already. People were scrutinizing her testimony, and already she came with an attitude that I think for me was very problematic because of invoking the thing of sub judice. Even though according to her argument, and the argument that has been raised by the head legal representatives is that even at the ad hoc committee, she did raise the same argument of sub judice, which is the fact that the matter is still before the courts. Therefore, she can't answer certain questions. However, it looks like her troubles are bigger than the sub judice rule. It doesn't matter even if we say we're going to apply that rule or we are going to invoke it, because her problems are bigger than that. She has just a lot to answer. And to tell you guys the truth, after the 2 days testimony, I think we are just 10% away. There's still a lot that this lady has to answer to, because today we're only dealing with section 27 only, of which we're going to discuss it extensively in this video. So I wanted us to start with the first statement. So her first statement was basically about the powers that she has and the fact that she has, then the why IDAC was formed and the purposes of IDAC. And she spoke about the committees and the fact that they have some kind of like a team. It's not really a committee that decides on matters. It's a team, of which, according to Padayache, we're told that it was a committee, but she's refuting that, which I'll get to some of the things that she has said that are refuting the testimony of Brian Padayache.
He is incorrect about a committee. These are, Chair, when you put to me about the juristic nature of things. After IDAC became permanent in August of 2024, we realized that there are certain processes that one would have to put in place. We have come up with a draft operations manual, very much like where the police have standard operating procedures. And it is in that draft operations manual, which is soon to be finalized, that you would find the suggestion of a committee. But there isn't, Commissioner Baloy, a committee. I also do not consider myself or Mr. Sesotho a committee of any sort.
She spoke about Mkhwanazi and the fact that the things that Mkhwanazi has said are not true about the IDAC, and that IDAC is not captured and that it still maintains its independence, and also refutes the claims of Matlala of Mkhwanazi in terms of the cases of Matlala and Katiso Molefe, and also spoke about the threats that after she was dealing with the cases that arrested Dumisani Khumalo and the co-accused has led her to threats that she was threatened together with her family. They were saying that they're going to put them in some bags.
Received the death threat directly on my cell phone. It read, Mrs. IDAC, you and your guy Shabalala, Perumal, Padayache, and Belochan have went too far. You're going to wish you did not, I think everyone that has a document can read that word, with us, get body bags ready, close quote.
And she spoke about the arrest of Dumisani Khumalo, saying that it was not politically motivated. She didn't know that Khumalo was involved in some investigations that are involving Katiso Molefe and Vusumuzi Matlala. The biggest argument is that there was prima facie. She's confident that they did not just construct these allegations or these charges against Khumalo, and that they are not charging Khumalo because they're trying to distract the work of the PKTT. They have a prima facie case against Khumalo, of which today, I think after today's cross-examination, maybe we can say another different story it doesn't look like she was, there is actually a prima facie case.
I deny these allegations. I expand on this denial as follows hereunder. 11.1. IDAC has a prima facie criminal case against Lieutenant General Dumisani Khumalo and other officials at Crime Intelligence. That matter was not pursued for any political purpose at the instance of any political actor or to advance any form of political interference within SAPS. 11.2. The investigation and prosecution have at all material times been dealt with through the ordinary prosecutorial processes applicable within IDAC and the NPA. The matter is presently before a court of law. I emphasize, however, that I have not been directed, encouraged, permitted, or participated in any politically motivated prosecution or investigation against Lieutenant General Khumalo or any crime intelligence official.
And then with regards to the allegations that were raised by the former officer, which is Mr. Rulofse, McLean, and witness N and O, the allegations that they raised against her regarding the docket that is involving General Khan, she invoked the fact that she can't incriminate herself and that this matter is currently being investigated by the NPA and that she does not want to, in a way, meddle with the matter or with investigations. She spoke about her relationship with Khan and the fact that it was business relationship, strictly business. However, the relationship, it looks like it grew to it being personal.
I have no knowledge of the existence of a Khan IDAC cabal in SAPS. I also have no knowledge of a Khan IDAC cabal within the IDAC. It follows that if such a cabal exists, I am not party to it. I have not authorized, encouraged, or facilitated its existence, nor have I benefited from any unlawful association involving General Khan, IDAC, SAPS officials, or any other person. I know Major General Khan as a general based at Crime Intelligence Head Office. Before I became the investigating director in March 2022, I engaged with him in meetings with other stakeholders, attended net joints or other SAPS meetings at which he was present and to which I had been invited by relevant component heads, deputy national commissioners or divisional commissioners. In late 2024, media reports emerged concerning General Khan's alleged involvement with persons allegedly linked to the Murray murders. Those reports concerned me because I had previously met with one of the Murray sons who wanted to know whether IDAC could assist with the investigation. I informed him that IDAC could not assist, but explained how he could escalate his concerns about the investigation to SAPS management. At that stage, the concerns of the Murray's son referred to above related to how SAPS organized crime Gauteng was dealing with the matter. 19, but it was He invited my husband who worked at Crime Intelligence, and when we got there, most people who had been invited were their partners or spouses, and we attended the birthday, attended the dinner. We probably were the most ungracious guests because it was very busy. And as soon as we had dinner, I said to my husband, can we leave? And we didn't even greet the host. We had left, but we did attend it. My husband having been invited, and I attended.
And she also spoke about oversight, of which that is where some of the problems started and some of the lies you can say they were formed. Because remember that team that I told you about that discusses things and decides whether they're going to investigate the matter or not. So she's saying that in that team, it looks like she was just removing herself from everything, as if she does not even have oversight powers and roles in all of this whole thing. Whereas she does have powers to oversight the IDAC. She has the powers of oversighting the IDAC. But it looks like all the blame is going to Sesotho, and the fact that the team that Sesotho is working with is the one that is making decisions. But she's removing herself. Hence, Khumalo was even asking her that it is your role. You are making these decisions. And she ended up conceding that actually she's the one that makes decisions, and she's also playing an oversight role.
There are two ways of looking at it. One is to say, we have investigated this case. These are all the facts. Please look at all the facts and decide whether this person should be prosecuted or not. That's one way of looking at it. The other way of looking at it is that you say, we have conducted an investigation, we've prepared a charge sheet, I'm satisfied that there's a prima facie case, I have made a decision to prosecute, and all they have to do is to say, I agree or I don't agree. So is it the first one or the second one?
The second one being from the DPP office.
From you, do you convey to the DPP that you've made a decision to prosecute, that this case should be prosecuted?
Yes.
Is that the decision you make?
Yes.
And that is what you communicate?
That is what is communicated. Okay. I would just need to check the wording is, do I say I made the decision to prosecute, or there's a decision to prosecute by the team? I would just need to check those words. Not to abdicate any responsibilities, but I should be clear about how I wrote it in there.
With General Khan, it's so shocking that she shares both the professional and the personal relationship, because she says that she would even express issues regarding their relationship changed drastically after that Murray case, and that, should slowly but surely tell Khan about her dissatisfaction regarding the SAPS investigation regarding this case, and was not just happy about all of this. But that's the thing, she's able to speak to Khan professionally and personally, but she wants us to believe that with her husband it's only personally and it's not professionally. So I feel like all of that is part of the things that I believe are lies that she might have told.
At the time, I didn't recall disclosing a docket.
Yes.
When the evidence is then presented and witnesses testify, I'm replying to this affidavit on the 10th. And then people are testifying on the 10th. And it is only then I realize what is being referred to. And hence the third affidavit that was then made. Because I now have more details about the docket that is being alleged to have been disclosed.
And these are some of the things that were contained in these three statements that she wrote at the Madlanga Commission that constitute her examination in chief. So obviously her cross-examination started and it was intense, I'm not going to lie. Let us get to it, because the crux of it is section 27, which is the reason why the case even existed against Dumisani Khumalo and the co-accused, including Dino Mukwele.
Nothing. You have accepted that there was nothing. Mr. Perumal, what motivated you at the time of your instruction to Mr. Perumal? Did I understand you correctly?
That is correct, Chair.
No, that's not a fact. Look at that affidavit. No. That doesn't answer me.
Number one, it is worth noting that it looks like we are dealing with an error lady. With a lady who makes a lot of errors all the time. Advocate Andrea Johnson, that's what I've noticed about her. There's just a lot of errors that are following her that she has done. From the error regarding her papers, some of the paragraphs that she has submitted at the Madlanga Commission, to an error when she was referring to Dino Mukwele, she said persons as if it's a lot of people. And now we are seeing another error that Madlanga Commission spoke to, which was the issue of subjective and objective and how the reasonable person test actually works.
In fact, it's paragraph 30 of
It
the
is
original
paragraph.
statement.
So the error had an error.
There I had an error, so to
And my
speak.
apologies about the error having had an error.
Is no complaint to IDAC about appointment and installation of certain persons, plural.
No, it is a person.
Person.
I correct myself. Thank you. Is understanding what the reasonable person, and went back into subjective. That was my error. It is an error. It was an honest error.
But we'll get to that whenever the time is right. But there's just a lot of errors. And we know that this is not the first time that Advocate Andrea Johnson makes errors and calls them human errors. Even when she was applying to be the National Director of Public Prosecution, in front of Pamgwabantu, the public, we saw that there's just a lot of errors with her papers. And part of the people that was just very disappointed and not pleased, that she doesn't proofread her work. For someone in her caliber and her position, it's very unprofessional. I remember I used to be taught even by my former principal, that you can't be making errors. Like there's certain errors that you can't be making because they don't make you look professional and they don't make you look like you know what you're doing. And that is what I think is happening with the case of Advocate Andrea Johnson. One of the things I've noticed also about the testimony of Andrea Johnson is that she's throwing everybody under the bus. And she's throwing Paul O'Sullivan under the bus. She's throwing Fadiel Adams under the bus. She's throwing who's this? Perumal under the bus. She's literally throwing everybody under the bus because she knows that if she corroborates their stories, she has even more things to answer to. So to just reduce the burden, she has to try cut ties with certain people, like her saying that she knows no complaint about Paul O'Sullivan, even when Paul O'Sullivan appeared at the commission and spoke about the fact that he lodged a complaint with the IDAC regarding this Dino Mukwele matter.
One I looked at first was the one by Mr. Adams dated 21 November because it was the affidavit. I am unaware of any referral with regards to this matter from Mr. O'Sullivan.
So she's denying all of that now. And that's the thing. You're thinking Paul O'Sullivan is the only one. Brian Padayache enters the picture as well. Brian Padayache, we remember that he came before the Madlanga Commission, said he has never seen that Section 27 referral, and that this Section 27 referral is seen by that very committee that Andrea Johnson said does not even exist. Said that the committee looks at the Section 27 referral, deliberate, and then choose an investigator. The investigator takes over.
Chair, as I undertook that I would get clarity from the team, he did have sight of the Section 27.
He was given, in the sense of being given.
He had sight of it. That's the answer I have.
You see, you may have sight, in the same way as, for example, police officers will flash their ID cards just like that. Or you may have sight in the sense that you are given the document, you read it, you internalize its contents. So was he given that document for him to personally read and internalize its contents?
So initially he would have had sight of it, and later in the year, when he had all the dockets.
No, explain having sight. That's what I'm interested in. What do you mean by that?
That when the team met, they engaged the 27, and he is part of that team.
There's nothing about the fact that, okay, the investigator, this is what the investigator is going to do, see the referral, discuss the cases, discuss what is contained in the referral. Because remember, there's a lot of problems in that very referral. Because number one, it does not raise any allegations whatsoever, which is then contrary to Section 27B, which is the one of reasonable person, reasonable grounds, which will substantiate that suspicion. So if you have a reasonable suspicion, then there should be grounds for that particular reasonable suspicion. And when you looked at the Section 27 referral Prima Facie at the face of it, it doesn't contain anything. So, Padayache was asked that how do you investigate something that is not even there? Like, there's nothing here. It does not even comply with the National Prosecuting Act, which is the NPA Act. It doesn't comply with that. And then Padayache decided that, no, it's not me. Actually, it's about Andrea Johnson who's sitting in that committee, which Andrea Johnson tried to fix and say, that one is lying. There's a team instead of a committee. And even in that team, the very same Padayache is part of that particular team, and even said the people that are comprises of that team. And I was even shocked that Sunel Pelechan is actually there, because she first said Sunel was not involved in the case of Khumalo, only went to give effect to the arrest, but at the same time she comes and says Sunel is part of the team. You see the lies of Andrea.
It's not an answer. Surely that's not an answer. You cannot just acknowledge receipt and then keep quiet. How will the ministry know what your issue or problem is? Why not raise it with the ministry that I'm not able to do anything with this because, as you put it, there are no annexures to your letter? Why do you just acknowledge and then fold your arms and do nothing? That escapes me.
Not do nothing.
You've just told us.
Acknowledge receipt.
Sorry. Thus far, you've basically told us that you did nothing. All you did was to acknowledge receipt of the letter.
Yes.
What did you do then? If you did do something, what did you do?
I honestly cannot remember. I have to cast my mind back to, in the acknowledgement of the receipt of the letter, I speak under correction. I'm not sure that I asked and indicated that there was nothing attached to this letter, because a few days later, by way of envelope, we get the Section 27.
You would have been told to file a Section 27. I mean, he didn't make it up. He didn't wake up one morning thinking, oops, I have to put in a Section 27 affidavit. So someone would have advised him to file that. That's why it's important to know, what did you do? What did you say in that acknowledgement of this letter? You must have said something before we get to you then received an envelope.
And the acknowledgement would have been typed from an internal computer. Surely you have that letter in your possession or a draft of it somewhere.
So that is what is going on with regards to that particular aspect of the team. So Brian Padayache destroyed entirely with regards to the fact that he said that he never saw that Section 27 referral. But according to Andrea, he saw it. I don't know if it was like this, he didn't read it, but somehow he might have seen that particular referral. So that's one of the things that I'm saying, that that guy was literally shoved inside Pakati, the bus. And if he doesn't get suspended or anything like that, it would be luck. Like, it would be really serious luck for Padayache to survive all of this. I think the reason why even the commissioners, especially Chairperson Cele Madlanga, the reason why he was asking this question and asked it over and over again is because, remember that this is perjury already. So if Padayache is actually lying, we are dealing with the case of perjury. Then now move forward to the particulars of Section 27. One of the things that you need to always remember, that I've even said on my other video when I spoke about Padayache's testimony, is that the IDAC is a creature of statute. And if someone is a creature of statute, they are bound by that particular statute. In this particular case, we're talking about the National Prosecution Act, which is the NPA Act. They are bound by that act. They can't make their own rules. They can't think about their own rules or construct things in their heads that don't exist.
IDAC is a creature of statute. It is founded in terms of Section 7(1) capital A of the NPA Act as amended.
So we know what Fadiel Adams did. Fadiel Adams decided to go to Orlando, Langlaagte, Cape Town. In Orlando, opened 3 cases, Cape Town opened 3 cases, and Langlaagte opened 1 case. In total, he had 7 cases. After 2 days, like two days, he then wrote to the minister, which is Minister Mchunu, or we can say the office of the minister, which comprises of the chief of staff, which is Nkabinde, Cedric Nkabinde, as well as Mchunu, and told them that he lodged the complaint that there was interceptions of the docket by the subs, and that is Adams. It was interception of the docket, and Adams lodged that complaint and wrote that email, which was read, and even I think I even uploaded. Then what then happened is that Mchunu and Nkabinde decided that they're going to then shift the matter and take it another step to the IDAC. Even Advocate Kumalo said something very interesting there. The commissioner said that they had 3 options as the office of the minister of police, the former minister of police. They could have taken the matter to the directorate. They could have taken the matter to IPED and IDAC, and they chose IDAC. And then what happened is that when Andrea Johnson saw that email, she just decided that, you know what, Padayache, please call Adams, tell Adams to do that Section 27 referral so that we can start with investigation.
Now, I want to suggest to you, so effectively, IDAC solicited a Section 27 affidavit from Mr. Adams.
Tell you now, when you look at the 27, we didn't take the 27. They would have contacted him, and I guess this is what we got. I speak under correction. Mr. Perumal would have to answer what he got from Mr. Adams, but what we got was a 27 dated the 21st of November, 2024.
That's fine. My question is, that document you're holding in your hand, IDAC solicited it from Mr. Adams. You received a letter from the minister. You then directed Mr. Perumal to act on that and contact Mr. Adams and
Ask him for his...
Ask him. So you solicited a Section 27 affidavit from a would-be complainant.
I don't agree with the solicited.
Ma'am?
I don't agree with solicited. We would have asked him, because you see, I'm going into the detail that's not mine and not in my head, and I don't want to sound like
It's yours, Advocate Johnson. You are the one who gave an instruction to Chief Perumal to contact Mr. Adams. So Ms. Sillo's question relates to that. That has nothing to do. Mr. Perumal would then have been the actor on your instruction. That's where the question is. It has nothing to do with what Mr. Perumal then did down the line. So please do not deflect the question and refer to what Mr. Perumal would have done or not done. Can you please respond to the question?
Right. So that's what happened. She didn't respond to the minister, didn't say anything. Just escalated the matters and started asking for Section 27. So the commissioners obviously were very not happy about all of this. Number one, this complaint came through the office of the Minister of Police. The person that was supposed to give that Section 27 referral is none other than Cedric Nkabinde. It is not Fadiel Adams. How can it be that it is Fadiel Adams? They then went, this thing of them going to solicit, because they solicited Adams' affidavit. That soliciting of that Adams affidavit is one of the things that are very, very problematic that the commissioners raised. That number one, you go, you solicit an affidavit from Adams through Padayache, through Perumal. What makes the matters worse is that Adams was never in the beginning supposed to be the one that makes this affidavit. The person that was supposed to make this affidavit is none other than Nkabinde, because he's the one that sent that email to them. And they realized that, you know what, let us try to help you guys, because you guys, there's no Section 27 referral here. So we're going to help you guys so that you can channel your allegations very properly. Then make your Section 27, so that at least we can try to channel you guys properly.
To Mr. Adams is to say the minister has received a complaint from Mr. Adams. Please investigate. And I refer this to you in terms of Section 27. So the person that must give you the affidavit is Mr. Nkabinde, and it's not apparent why you thought that this is a complaint to IDAC from Mr. Adams, because it's not a complaint from Mr. Adams to IDAC. At this point, it's not.
What was Andrea Johnson supposed to do according to the commissioners? After receiving that email, because according to the minister, it looks like that was their Section 27 referral. She was supposed to clarify the letter of the minister and write back the letter or whatever, email, whatever that she wants to write, and tell them that, you know what, that is not how you lodge a complaint with the IDAC. This is the process in terms of Section 27, That was what she was supposed to do. Instead, she went quiet and told someone that was just mentioned in the email that later complained with them, but that is not the same person that came to the IDAC. Then now they go and tell this person, solicit, and say, hey, brah, come, you know what, just write the Section 27, we're going to deal with you. The second thing is that even after that Section 27 has been now written and has been given back to the IDAC, that affidavit has no allegations whatsoever. We're still going to learn as to how did it end up with the investigations against Mukwele's appointment. But that Section 27 referral was just about the interception of the dockets. It had nothing to do with the investigation that IDAC ended up doing.
So, if you understood the request to be an investigation into the alleged interception and interference of dockets opened by Mr. Adams, that surely should have been the confines of your investigation. Whether or not dockets were opened and intercepted, whether there has been interference with the dockets, regardless of the content of the dockets. Because otherwise, you would have been investigating what you were not requested to investigate. Would you accept that your investigation would have been that narrow, would be looking into the interception only?
In terms of this letter, yes.
Yes. So, we then, if we look at the emails at 283 and 284, that is consistent with what Mr. Adams complains about in his emails to the minister. It is the interception. After tea, perhaps you will shed light on having solicited the Section 27 affidavit as IDAC did. How do we end up with claims of Kumalo Lushaba Madondo siphoning money from the secret account fund, with cover-ups of General Lushaba's incident with the appointment of a lady working at BMW in a sensitive post? How does that fit into the request, specific request made to you of interception? Why is Mr. Adams's affidavit not confined specifically to the complaint he had laid with the minister? It was that at the instigation by IDAC. It can only be at the instigation of IDAC. So there is Mr. Adams' complaint of interference, and then there seemingly is a parallel investigation attached to that complaint initiated by IDAC. Is that where we are at?
I'm going to come back to you after tea because I'd have to speak to Mr. Perumal about what he spoke to Mr. Adams about.
So we're still going to understand as the days goes by as to how did the IDAC go and get there. But according to the information that is revealed now at the Madlanga Commission, Andrea Johnson literally woke up and said, you know what, do a referral, and that referral is about the dockets. And they thought the only way for them to investigate this interception is for them to get the dockets. Get the dockets like they did, get them unlawfully, and then start with their investigation. But that's the thing. Even that very Section 27, as I told you guys, it's just allegation. There's no reasonable suspicion that you can see. There's no prima facie, or there's no grounds for a reasonable suspicion in terms of Section 27B. So literally what was going on there is that Miguel had to be taught in terms of a reasonable person standard or test, if whether it's an objective or subjective standard, which we all know. If you've ever done LLB, especially from vets, you'll know that a reasonable person, because guys, I'm not going to talk about other universities. I don't know other universities, how they teach law. That is why I'm specifically talking about vets. I'll be so disappointed if you're a vets graduate and you don't know the reasonable person standard. Guys, delete. We've been taught that thing on delete. All of us were getting distinctions because we had one of the best lecturers in delete that was teaching us this test to the T. And this is an objective test. It's not a subjective test. But according to Andrea, that is a subjective test. Meaning where now you can just look and say, I'm taking this case. Whereas it's not like that. A reasonable person standard or a reasonable suspicion standard, it's subjective. Meaning that even someone else that did engineering would look and say, there's a case. Even someone that did medicine will look and say, man, there's a case. But here, Andrea Johnson is saying everything is subjective. Hence, he was even given lecture, Introduction to Law 101, or I don't know if it's Introduction to Delete 101. Because for us, in my experience and my education, we did a lot of delete we did a lot of reasonable person test, a lot of it extensively with the module delete.
You say the test under Section 27 is a subjective test. Do you stand by that? Because if you do, it raises very serious issues about your application of the section
Yes.
over all these years. Are you sticking to your assertion that the test is subjective, even though it uses reasonable? Once you have reasonable, that leads to the objective test. You should know that.
Yes.
Are you insisting that the test is subjective?
It is an objective test of the reasonable person.
It's an objective test.
Yes.
Yeah, you don't even need to go to reasonable person. Reasonable person is implied in the concept of an objective test. So you don't even need to go there.
So literally, that's where we are with this testimony. We're still trying to understand how it ended up with Dino Mukwele, how it ended up to be the way it is that police officers were even arrested as a result. But what we know is that Section 27 referral, there's a lot of questions about it. There's a lot of questions about it. But before, I don't want to make this video too long, guys. Let us quickly talk about Matlala's case. So cross-examination continues, and Bethwell Cele is still before the judge and before the court, and Judge Musa was guns blazing today and was not happy about the conduct of Usmoziket Matlala's attorney. But before we can get there, let us talk about Diego Mabusele's attorney, which is Advocate Grove. I think it's Nardis. Grove Nardis. So he was speaking about the scene of the crime, and trying to make the witness to point out as to what is what, where is what. Because according to him, I think most of the times that's how defense attorneys work, guys. They want to put you in the scene so that they can understand where was what, where was who, and they can be able to detect if there's any lies and discredit you as a witness. And sometimes they even use your character. As people are even saying, oh my God, the witness is rude, Mr. Cele is rude. And I think that's one of the witnesses that if the defense can use against her, that can collapse even, that they can use against him and can collapse his testimony. As much as I think he came in strong, provided strong facts regarding what happened on the night, but I think to a certain degree his character might be used against him. And I'm saying this because, guys, we're taught Law 101, Introduction to Law 101. When you're doing Criminal Law 101, I remember my lecturer was telling us about the story of a guy that was being cross-examined, and this guy didn't like the noise that comes with the pen, and the defense used that to get him to be frustrated and end up saying things that are going to prove a certain point about him that is not a credible witness. And I think that is what is going on here. We might laugh about it and say, oh my God, we are Papa in Ini, he coming in guns blazing. Those are the very things that will collapse his testimony if he's not careful. I'm not saying he doesn't know his story, he knows his story, and I don't blame his frustration. I think he has all the right to be frustrated with the process, because it looks like everything is going round and around and around, and they expect him to do counts They just don't want him to just count and just say a tree, there's trees, there's parking lot. They want him to count how many trees, the parking lot, how many spaces are there. They want him to give detail of that, and he ended up being frustrated, saying that that is not his job. He's not there to be counting trees, to be counting parking lots. That is not aksudogo gaileyen. Like, it's not his business at all.
Indawo zokupaka zingaphi la?
Hayi angaze ngwaba.
I've never counted them.
Umsebenzi wami bekugada hayi ukuzokhawunta ama-parking.
My work was to guard, not to count on parking.
Yeah, I'm not trying to trick you, and I'm not asking for an exact answer. An approximate. Is it approximately 10, 15, 20 bays? Or is it only one or two?
Akazangalala ukukulinga nje ufuna ukuqekelela. Actually, I'm parking indawo zokupaka zingaba u10 noma zingaba u15 noma zingaba u20.
Yena ngoba ube khona wayengakhawuntanga yena. Ube khona nje nekuseni namhlanje ushilo. Ngesikhathi uthatha ithombe.
Because you were there in the morning, why didn't you count them?
I did, sir.
You indicate to this court that you were there in the morning and
Yes.
you also took some photos.
Yes. And now the court has ruled that I can't show that photo to you. And I can't give evidence as to how many parking bays there are, so I now have to get it out of you.
Sure, angizange lapha yabengayelanga ukukhawuntana nezihlahla. Mina bengiye lapho ukuyogada, ukuyocount izihlahla.
There isn't for me to be there. I was not there to count trees. I was there to guard.
Hayi ungangifaki mfethu.
But you see,
Don't
sir,
involve me there.
And futhi ngaliphinda nale themba ezolo lithi akudoko eligwaye eqalwe mina ukuthi ngiyokhawunta izihlahla lapha ya ngibe ngigadile ngibe ngikhawunta izihlahla.
You know, I was there. You are bad luck actually. I was there.
And they started talking about the scene itself as to what actually happened, and especially him shooting at these people and, you know, the shooting back that happened. And I think more than anything, what I can grasp from the defense is that they're trying to find ways that are going to discredit the witness. And they're trying to find ways to say, this witness is not someone whose account can be trusted. Hence, you might think, oh my God, we are going round and around. We're talking about this scene over and over again. He's already spoken about this. These things, guys, are strategic. And with one thing, the entire testimony can collapse. With one thing, they'll get what they're looking for. The trap of what I'm talking about is here. For example, he was asked regarding the shots that he fired at the guys that were shooting at them. The shots that he fired in total, it was 15 from what he testified, including from the ballistics because of the cartridge cases that we found on the scene. And at that time, I'm assuming the heat was heating and they were shooting at each other. At that time, it's not even clear if he might have shot Mr. Joe Sibanyoni. And that is what the defense is putting to him, that he's the one that probably shot Mr. Joe Sibanyoni because they were literally shooting. They were shooting.
Amanye wamabhuleki la adutshulwa nguye ngawo ayenza ukuthi ba uSibanyoni ajubuleke.
Ngiyaphikisa lokho.
I'm not agreeing to that.
Thank you. Now, I put it to you that the impression that I get is that initially you were quite scared after you and I fired for 15 rounds and Mr. Sibanyoni was injured, that you made up the story that you gave in your first statement that night.
Kuthi-ke manje ngokuthuka kwakho ngokwesaba kwakho uye wasaba ukuthi-ke manje ba uSibanyoni manje ulimele ke manje wase ubhalisa statement owena uzenzele sona wakhuluma iqiniso statement sakho sokuqala.
Nginganifula kamzamo le. Imhlula yami straight le. Ngenelwa indledleni la.
This is
Hayi ngiyahlolela straight.
This is a miracle. No, it's not like a dog now entering my premises or inside my house.
And the fact that they were just shooting, it proves the point that high chances there might have been one or two shots that have shot Mr. Joe Sibanyoni. Because how is it that he was never touched? Even though I think he raised quiet, even though people laughed, but it was a good argument that if he could survive those many shots that were shot towards his direction, there's a high chance that Mr. Joe Sibanyoni would have survived. And another argument that he has raised is that he never shot on the direction of Mr. Sibanyoni. He was just focused on the BMW, which is the car that had these people that were doing the hit, which are the izinkabi. So they're the ones, he was just shooting at them and focusing his shooting towards those people, not towards the direction of Babu Sibanyoni. But as I've said, I feel like it was just, the scene was, there's just a lot of things that were happening. You can't be shooting and you capture everything, who was where, how, and all of that. And I think that's what the defense is capitalizing on. Yesterday, they capitalized on the dates. They capitalized also on the fact that the scene might have been tampered with, and today we are finding out that also the fact that he was just firing shots around 15, there's a high chance that 1 or 2 landed on Mr. Joe Sibanyoni. Probably also he should be charged for attempted unaliving.
The other side of a BMW. The Ferrari and the Golf, or let me rather put it this way, the BMW was between you, the Ferrari, the Golf, and its occupants. So if you missed the car, you could very well have shot one of them.
Uthi ke manje uyakutshela ngoba isizathu sokuthi akhulume lokho akhulumayo phakathi kwakho nensola boyalesi legebengu bekume lapha na iBM
bebe jive lapha bezele uzojive.
I'm still asking what were they doing there, those people? Were they there for a dance or what? What was the reason for them to be there?
And I think his response, it depends on how you look at it and how you are. I just think that other people, that's just how they are, guys. You remember when you were listening to Bheki Cele's testimony, you guys were laughing there. Because that is just how his character is. And I think with Babu Cele, he's also like that. Oh, what a coincidence. Cele. With also Babu Cele, it seems like he's that person that can easily say, Udagi, we are better. Just, to express how they feel about what you are saying at that time. And it's up to you whether you're going to see that as a disrespect or you're just going to see that as a response. And I know that many people might see that as a disrespect. I had a worse principal, guys. I had a principal that would tell you straight in your eyes that you are dawa. And I never took that to heart. So... you slim. I go back and do your LLB. Are you sure you did your LLB at Vets? Are you sure you didn't do it at UNISA? Those are some of the remarks that he would make. But we never stopped. Some of us never really took offense. But clearly it looks like they're taking offense to the way he's answering. And also, he was saying that when they were shooting towards the direction of the Gulf, the people in the Gulf, they ran away towards the BM that they came in with. And it's just... There's just a lot there that is going on with the testimony, guys.
Was a BMW and a Golf. Because the occupants of that BMW, they were shooting at the Golf.
And the people from the vicinity of the Golf was running in different directions. That's your evidence, sir, not mine.
They ran towards the BM.
But as I've said, it looks like they are trapping him and they are using his character to trap him even more. And the scenery, the scene itself, to try to push that defense. And I just think they're doing a good job so far. I just can't wait for the legal representatives of Matlala. You guys I think that one is just going to take 3 days.
Then what will target 9 times?
Bona labe AK bamiseka ngakhe. Laba bedubula ngeAK bona badubule ini bona.
Those who were using a rifle or AK.
Ngoba ubonda lo la Centurion lalibolile amabullet. Even izindlu zabantu zalimala bakutshelile lo.
Did they tell you that even the halls of there at Centurion, there were bullets on the halls?
Even the houses zabantu zamoshakala.
Even the houses, did they tell you that? Did they inform you?
So I'm not here to answer your questions. You are here to answer my questions.
And also, another thing that they raised, which I think is one of the things that are making Mr. Cele look like he's contradicting himself, is that he made 3 statements. And those 3 statements have different facts, which is the same thing he was questioned about yesterday, which has landed him with the problem with those defense attorneys, that he spoke about a different timeline compared to other statements. It's the same situation now. The reason why they're extensively cross-examining him regarding these cartridge cases and these firearms and these bullets and whether there's a possibility that he might have shot Mr. Joe Sibanyoni is because of his contradictions in these statements that they've seen, these 3 different statements that are before the court. And another thing is the fact that this man is currently working for Joe Sibanyoni as I'm talking to you right now. I don't know if he's working for him directly or he's working for the companies, one of the companies that Joe Sibanyoni owns. And they believe that he has an ulterior motive, and because of that, of him working for Joe Sibanyoni, it's one of the things that they're using to say that he's testifying against the accused persons because he's an ally in a way of Mr. Joe Sibanyoni, or he's working for Joe Sibanyoni to push a certain agenda.
Counsel is asking you a simple question. It doesn't require a long explanation. He's just simply saying or putting a proposition to you. Is it not correct that you are employed by Mr. Sibanyoni?
No,
it's either a yes or a no answer. What is your response?
Yeah, my answer is no.
Have you never worked for him?
Mr. Sibanyoni,
ngimsebenzela through any company.
I work for him through another company.
Oh, so you did work for Mr. Sibanyoni. Are you still working for him?
Sorry, before the witness answers that, the answer he gave is that he works for Mr. Sibanyoni through another company. Yes. I think it's only fair to give him the opportunity to explain that.
Thank you, madam. Please explain.
Ngimsebenzela ubaba uSibanyoni through any company. Angisebenzi na direct. Angibhadarwa uye.
I'm not working direct with Mr. Sibanyoni. He's not the one who's paying me. I'm working for him through another company.
Obviously, Mr. Cele has never said that Mabusela is the person that unalived. Has never said that any of the accused person are the people that attempted to unalive Joe Sibanyoni. He's never said that. He just described the events without pointing at the faces of those particular individuals. Because the defense are starting to raise an argument that there's no way that the clients are the ones that might have tried to unalive Mr. Joe Sibanyoni because his clients are Sotho speaking. While Mr. Cele said that the people that tried to shoot him, to try to unalive Mr. Joe Sibanyoni, are Zulu speaking. And they tried to use that argument to push a certain agenda. But yeah, so far that is what is going on.
He said accused number 2 will dispute and deny ever being present on the scene on that evening. What do you have to say?
Uzatshela inkantolo ukuthi ke manje yena bengekho kwindawo esigameko ngelela la uthini bayasho kanjani
ake ngimphikise ake ngivumelane naye vele kakadeni angizange ngithi mina ngizothi mina accuse number 1 or accuse number 2 or number 3 or number 10 wayekhona.
Yes, my lord, I will not dispute that, my lord, because in my testimony I never mentioned their name. I've never said that. I've never mentioned the name of accused number 1 or point accused number 1, no, accused number 2, or accused number 3, or accused number 10.
The second aspect that is being put to you, that accused number 2, if called to give evidence, will come and dispute and deny that he speaks isiZulu.
Manje futhi umsolo uyibekelwa futhi kusho ukuthi umsolo wesibili meza la ethatha leli bhekisi uzawutshela inkantolo ukuthi yena akakhulumi isiZulu.
Ngingamvumela kusegoli.
Then another thing that they started with was the issue of the photography. So the advocate went to the scene, took pictures and wanted the witness to actually point to those pictures. But that was heavily challenged as testimony or as evidence that cannot be admissible. And that is because, remember that yesterday, that's what the defense did. They didn't want the CCTV footage to be admitted. So now they're in the same shoes now. They can't admit these pictures because they're raising issues that how authentic are they? Are they AI? And all of that. And that is when we saw the advocate that is representing Matlala started inserting himself in the cross-examination of someone else. He had no basis to raise any argument regarding this whole thing of pictures because, as I've said, guys, she's not involved. It's not her cross-examination. It's the cross-examination of Advocate Nadis. So Advocate Nadis is the one that has to speak and try and make arguments, not someone else.
Was taken, I think, soon after the incident. So it would be approximately 4 years ago. The photographs that you have today are obviously post 4 years from the incident. Would you be perhaps amenable to use the photograph album?
With respect, no, my
Would
lord.
you
For the
be
simple
able to use the
reason-
photograph album that was produced shortly after the incident?
What is important to me, my lord, is certain angles and what is visible.
Okay,
I
good.
haven't seen these still photographs, but they're taken at night, and it's, from what I've seen, hard to see. These photographs are very simple photograph of what the estate looks like. If my learned friend looks at it and she says, I have a problem, that's not what it looked like, different story, but I'm sure that's something that the witness can deal with.
So that is basically what was going on. And yeah, I think it's very interesting. It gives you a glimpse of criminal law and how criminal law in practice actually works. And I'm still going to say, I think this trial doesn't need, it needs more than a month, especially at the pace that these people are moving. The whole day we're hearing Advocate Nadis, and he was moving in circles, talking about the scene over and over again. Tomorrow it will be attorney of Matlala. The other day will be that. So one witness will take the stand more than 5 days. Because we have 5 witnesses, we have 5 accused. So which means we'll just have the same attorneys doing the same thing over and over again, and one attorney will need a day, the other one, so which means a week we are dealing with one witness. You see what I mean when I say that a month is not enough, 30 days. It's not enough for this trial, guys, especially considering that there's a lot of witnesses that still have to be heard. If they were moving in a fast pace, by now we could have been hearing another witness. But they are moving very, very slowly. And I think if this is how they're going to move, I'm telling you guys, I have this experience. I'm not talking because Nilululu or Sululu. I have experience. I remember even with the Marikana case, the reason why to this day we don't have prosecutions is because of such behaviors. It's because of such behaviors. You guys will go attend proceedings and people will be asking, the defense will run, and the defense again loves this because when they're just making money. The more they spend in court, they're just making money. So they don't mind speaking about the scene. And they'll say, they're trying to prove a certain point, but you never really see the point. So unfortunately, that's what I think is going on with the case of Matlala. I don't know what you guys think. Let me hear your thoughts about everything, Andrea Johnson's testimony and the Matlala case. Otherwise, guys, I'll see you on my next upload. Bye.